Welcome to the Neural Implant Podcast, where we talk with the people behind the current events and breakthroughs in brain implants in an understandable way, helping bring together various fields involved in neuroprosthetics. Here is your host, Ladin Yurachek.
Hello, everyone. Welcome to the Neural Implant Podcast. Today's guest is a repeat guest, Eugene Daneshvar from Black Swan Intellectual Property. And so last time we talked, you were working for a different company, I believe. We're talking about patent law, filing for intellectual property for neurotech devices. And now you're at a different company. So welcome, first of all. And I'm excited to talk about your new adventure, your new endeavor. So do you want to introduce yourself better than I just did?
Well, thank you so much, Lava. It's such a pleasure to be here as always. I love listening to your podcast. They're so authentic, and I think that's this is kind of the experience I bring to my practice. And as you may have heard, it's difficult to change any large organization. And I had sought to build a neurotech-focused practice, but I didn't have a willing partner in my last firm. The last firm's patent practice mainly focused on pharma and pharmaceuticals, and that has much deeper pockets than medical device or neurotech. And they control my hourly rate, which come January 1st went up to about $1,200 an hour, which is too steep for my medical device clients who are being compelled to find help elsewhere. And I decided to be that elsewhere. So you get contagious entrepreneurship. I loved helping entrepreneurs, and I'm like, why don't I be one too? So I'm excited to talk about what I'm up to. I kind of see myself as kind of like the in-house counsel, specializing in IP for my clients. I offer patent prosecution, which is your run-of-the-mill type of things, doing a landscape search or surveying the field, doing patentability analysis, vet an idea, determine if it meet the threshold of patentability, do freedom to operate. And once a product, there's features to search for. I do IP due diligence. I pretty much analyze claims to product coverage and make recommendations to pursue new meaningful claims. IP due diligence also includes some of these admin related things relating to the documents, make sure they're in order. As you know, in the US, ownership starts with the inventor and is assigned later based on other agreements like employment agreements. But most exciting, I want to say, is I do flat fee billing. So no more billable hours. Everybody hates billable hours. And so it's a win-win for myself and my clients where they have predictability for how much things are going to cost. And I myself, I save time by not having to track every 1.1 hours of my time.
Yeah.
But
That's really exciting. Yeah, that's really cool. Starting your own, boutique law firm, specializing in, neurotechnology, right? Is that what you're specializing in, or medical devices in general?
I'd say, it's more what I don't do is how I would say it. I don't do the pharma related things, and I don't do just hardcore double E type things, even though I've got a background in double E. I wanted to make work in areas that I can add value to. So although I am a neurotech patent attorney, I also represent robotic surgery clients, and my wife's the OBGYN. I get exposed to a lot of different types of tools for surgical tools, et cetera. So I do some of that as well. And other people who know me, who trust me, who do have, I do have an autonomous vehicle type client, mainly in an education capacity. I help him with his filings, but I don't seek out that work, but I'm just known as a trusted person. And so I give it to them very candidly, what do you need to do? How do we protect this innovation? But mainly I'd like to focus on areas in healthcare, whether it's implantables, not implantables, digital health. I can help provide value.
Do you want to remind people of your background? Why do you think you're competent in this field?
Well, if they're part of your podcast and listen to this, they've heard the other one, but sure. So background, electrical, biomedical engineering, dual undergrad, master's, PhD, University of Michigan, mainly was MEMS-based neural electrodes that I was trying. My claim to fame was making movable electrodes that could reposition themselves either during insertion or after insertion. And you can think there's different applications, whether you're recording or simulating and trying to get that last couple microns would make a difference for whether you're recording or simulating. And that required me to learn a lot of materials. I was using some type of conjugated polymer actuators to work inside the body. So a lot of characterization and mechanical. And then you end up being a jack of all trades when you do your PhD. So I ended up having to learn a lot of mechanical engineering for designing what can be done when it comes to electrodes and interfaces and materials. But then ultimately, I had to determine the feasibility of long-term lifetime of these devices as well. So yeah, so that was my PhD work. That was I graduated in 2014. Since then, I've got over a decade of experience now in IP and different aspects of IP. So for instance, I've been an expert witness in IP litigation for neuromodulation technology. I've represented Fortune 500 companies, mid-sized companies, growing companies, solo inventors, and even some non-practicing entities, or you call them patent trolls. And I actually really learned a lot from representing them, because the quality of disclosure really mattered, because they wanted to compel a practicing company to license the invention. But yeah, I mean, I ended up working in many different areas with my clients from different areas. But as far as my interest, as I mentioned in the last podcast, I was born missing some fingers on one hand, which has really been the chip on my shoulder to learn the science well, and now try to be an advocate for other innovators and scientists who want to translate their into the market. So now I'm the catalyst to help that happen.
Yeah, that's exciting. That's really cool. Yeah. So I think somebody with your experience, both in the legal side of things and having a PhD, that's a rare thing. And I'm liking, actually, so I didn't know this. We went into this not having talked about, your new venture, but I really like this flat rate billing. I think that's really exciting. It was really, yeah, we had worked with you, and at the $1,200 an hour, I think I calculated that like every word that you said was like $30. So it really stressed me out talking to you. I'm just
no,
we got to talk as fast
I
as
barely
possible.
billed for your work. What are you talking about? But I will say, so that's not all, the commercial. So I have three aspects of my practice. First aspect is the bread and butter IP work that we talked about. The second aspect is investing. I'm also an angel investor. And so I have very founder-friendly alternative fee structures. So I do deferrals depending on what they need. If it's 30 days, 90 days, up to when they get funding. And I even sometimes with some clients, I do take shares instead of cash. Again, it depends on the opportunity. I'm an angel investor where I participate through life science angels, and we try to help companies raise money. So life science angels invest in life science startups that are incorporated in the US and have IP that's either owned or licensed by a US entity. And they invest in pre-seed through Series A, typically between 200,000 to $1 million. And so that's another way that I help my clients, is to help them be prepared to be invested in, and then I invest myself. The last part of my business that I'm excited about is doing a deep dive in the market research, getting up to speed with what's the latest and greatest, do a landscape on contemporary issues, and then I think that will both help my IP work and my investing idea. So three legs of the stool here.
Yeah, that's exciting. Yeah, that's really cool. And you can definitely do more than just a lawyer. And I think in that case, it makes more sense to have your own firm, because then you're not limited by these other things. You could, not be allowed to do something like that. I don't know what your agreement was before, but yeah. So, okay. So I don't want to put you on the spot, and I know prices might change and everything like this. So what's a typical price, or like what would one expect going into an agreement with you? Okay, we want to do this versus this versus this. What might that cost look like? How does it compare to industry standards? I mean, answer, I guess, however you want to answer, I guess.
Yeah. So I think, the first thing I'd say is, when you consider who to work with, you can price shop, and you can also see, what do you get out of the experience. And so the first thing I care about is making sure that my client is using their money well. So I am not going to push them towards filing if that filing is not going to help them achieve their aims. That being said, again, I feel like that's part of customer service, that's part of education. And that's one of the things I care most about is helping educate our community about the process. That's a typical application. We say non-provisional application. So when you first file, you can file what's called a provisional application that doesn't end up being seen, but it kind of holds your place in line in terms of your disclosure date. Then and that can vary. So provisional can vary between, you can file a blank sheet of paper and that would still be a provisional application, versus you can prepare a full non-provisional application, very formal, and nice drawings and claims, and you can file that as a provisional too. So I think the provisional is a little bit of a harder thing to pin down, the price point to pin down, because it depends on what the client seeks. But I think a non-provisional would say is typically between 12,000 to 15,000 is the market rate, given the complexity of the technology and what the ultimate intention is for the client. If they want to put all their ideas in one application or split them up into different ones. But I think what that entails, and I have two different tiers that I offer. In tier one, it's very plain vanilla. They help the innovation and I help draft innovation. Tier two, and this is why I started my firm, is where I roll up the sleeves and I help dig in. I'm not seeking to be an inventor, but I show up at the client site wherever they are. So if they're in Florida, I'll visit them in Florida, look over their shoulder, see what they're doing. And by just being there, you see different aspects that it's an old school way of doing things. Aside from just meeting people virtually and seeing them on Zoom, I think there's a lot of innovation that's lost in translation or lack of translation. I think that's what I'd like to offer, is a partner in doing the invention disclosures, not just putting it on the shoulders of the client, but just having a conversation. I think being there. So that's more on the 15,000 end. But if it's just a matter of here's my disclosure, convert this into an application, that's more on the 12,000.
Okay, that's pretty good. Yeah, that seems very reasonable, and yeah, excellent. So what are some other services that a neurotech or medical device startup might need, and what else would you recommend at what point too?
Yeah, so I think I think our scientists who are listening to this, they're very good on the identifying the scientific problem and solving the scientific problem. And I think what I realize, the business design is also really important. And I think my experience in vetting companies, doing due diligence for the companies that come for angel investing, you really see patterns of who's ready for taking the next step. And so I'm also going to conferences. Actually, I'll be at LSI, the Emerging MedTech Summit in March, and I'll be at the Bioelectronic Medicine Forum in New York City in April. I'll be at the Neurotech Leaders Forum, which I'm always at, in November. And there you also see, different stage companies dealing with either the raising the capital or going through the regulatory decision tree. And if it's not so much that it's more about issue spotting and helping them get the right resources earlier than later so they can actually do a course correction. So I have partners in the regulatory space. I have partners in raising money. And one partnership that's here, I think I mentioned to you, is called the Fogarty Innovation. They're an incubator, actually a nonprofit incubator here in Northern California. It's like 5 minutes from my house. And they actually offer, I highly recommend everyone to look them up, it's fogartyinnovation.org. And they have 3 different programs. They have something called a company in residence, where they actually host companies, entrepreneurs and their teams. They have a ton of wet lab space. Pretty much you think like the R&D section of a company is hosted there. And companies can stay there for about 2 to 3 years. I don't believe they charge them rent. And they teach them all the different aspects of R&D IP, quality systems, clinical and regulatory affairs, etc. They have another program called Company Accelerator Program. It's a 6-month program designed for early stage, Series A, Series B stage. We're really accelerating their growth. They're getting through all of these kind of commercialization tasks. And then they have this last one is called the Innovation Accelerator Program, and where they have typically they're physicians at hospitals nearby, El Camino Hospital, Mountain View, Sequoia Hospital, in Redwood City, that they help physicians who come up with ideas, like vet their ideas, we'll talk about concepts. And I have a couple of physicians I've put through that program as well. And I think working with an IP attorney, I'm not just an IP attorney. I kind of help walk with the innovators with all the next steps they have to do and help connect them to the right resources.
Yeah, that's pretty exciting. Definitely more of a full service thing. Okay, so before you were working in a famous law firm that had very well known name and everything like this. So what do you think? I mean, is that something that how important is the name, and what work do I guess the partners, or what comes with a good name like that, and then what can I guess people expect from your small firm as well?
Whoa. Small. We're talking about, the name Black Swan, actually refers to like an unpredictable, unforeseen event with extreme consequences. So be careful with throwing out a term. It's people hire attorneys, not law firms. So even whatever attorney brand name that you think you have is actually ultimately a particular person there that you partner with. Hence the term partner. With each firm, or think of a brand, they have different things they're good at. And Wilson Senior was mainly known for their corporate side of helping companies raise money. They weren't necessarily known for their patent practice, with the exception of their life sciences ones for the pharma. They're very strong at pharma. They're the go-to firm for pharma. They don't have any partner in medical devices. They had one that retired the month before I joined. Actually, they wanted to be trained under him, but he left and they never filled his spot. So one thing I liked about them, though, and the things they taught me, was working with deferred billing. Give high quality work and we'll bill you and wait until you raise money. Like, I learned that from them. And one of the things that I liked about that is that there's a little bit of a relationship building that you have with a firm. A lot of other firms, they make you pay a retainer because we don't know if we're going to be around in a year to pay off that deferral fee, right? But my practice, I've learned from Wilson, and I'm like, you know what? I like that. I like the relationship building aspect. I like taking a chance. You took a chance on me, I'll take a chance on you. And so I replicated the good things I liked about that firm. But I still work with the corporate counsel. So if you're still trying to raise money, you can still work with me. I just think you just go to a particular brand for what they're good for. And if you're interested in raising money, you find who are the corporate counsel that may help raise money. If you're looking for patent work, what matters to you is who can get strong patents. And actually how I picked my quality of my mentors over the years was I took a look at who were the winners, look at the claims, look at how well the claims are written, look at which claims went to litigation, because I worked in IP litigation for many years. And I also defended patents in what's called IPRs, or post-grant practice. And from there, I learned about the quality of the whole patent as a whole and the claims. And I'd say scientists who understand good science, good IP practitioners will refer you. Like, for instance, if you come to me in an area that's not my specialty, I'll refer you out to somebody who can do that better, because I care about my brand. I care about representing the client's best interests. So just like a physician, you'd find the specialist that helps whatever need you have. You go to a general practitioner for one thing, you go to a specialist, neurosurgeon for another. And I think you ultimately, it's not like you just pick a hospital based on the name. You pick a particular doctor who is good at doing that surgery if it matters to you. And I think that's what I offer through my background and also through the investing that I do, because I'm actually investing my time to get re-equipped, show up at the conferences, read the publications. And so I have up-to-date information on what is patentable, what is new, what is old, and that ultimately saves time. I have a client that I gave him some bad news this week. I'm like, listen, this idea of yours has been shown here. And if I hadn't done that, he could spend a ton of investment in trying to pursue an idea that had a dead end. Instead, now he can get exposed to that idea, think about whether that idea solves the problem as good as his could have. And from there, we innovate. From there, we're a partner. They're not gone. I'm just working with them on a different aspect of the problem. So I think that is my brand. That's what I care about. And I think the IP field by itself doesn't work on that model. And hence I'm an entrepreneur and I'm changing the model.
Yeah, this is startup potential. Maybe even launch some kind of completely new, yeah, like you said, model that's like revolutionizing thing. Maybe a new legal Zoom or whatever, some kind of other
Yeah.
model.
So my aspiration within the next year or two is to probably launch my own accelerator. Really, if there's partners out there, we're listening to this, or if you know people you think would be a good partner, I already have a regulatory consultant looking to join me. And we're trying to feel like we want to kind of be, I wouldn't say one-stop shop, but really help tackle medical device innovation, neurotech innovation from all the angles that are needed early on. A lot of people go towards they leave certain things for much later when really they should be tackled early on. So I think that's the thing. But you're right. Like, what is it that we need? I think Fogarty Innovation is great. They're a nonprofit that really helps educate but they're also related to the Stanford Biodesign program. And I think I myself have been trained in that type of program. And I want to offer those same lessons for my clients.
Yeah, that's exciting. Yeah, exactly. Coming back to this full service, I guess, for medical device or any type of innovators. So, what do you think is missing the most? What do you, in your experience, is something that you wish people would do
I
more?
can tell you right now, top of mind is using AI to invent. I'd say a lot of disclosures I've been seeing lately, you can tell they were AI augmented. And the USPTO has some regulations and some about using AI, coming up with discoveries. And I'm just going to read this, verbatim from them. It's to be named as an inventor in a patent application, a natural person must make a significant contribution to the invention. A person makes a significant contribution to invention if they, one, contributed in some significant manner to the conception of the invention. Two, made a contribution to the claimed invention that is at insignificant quality when the contribution is measured against the dimensions of the full invention. And third, they did more than merely explain the well-known concepts or the current state of the art. So that's like the rule that they applied for AI. Is it like what a natural person, what is it that the AI did versus what the person did? And in March of this last year, they provided some examples that I'm happy to share. They had this one example about making an addition to this toy robotic car, and they had different varying levels of human involvement in the conception. So, and they have 5 scenarios. The first scenario, they had natural persons take output of an AI system without any alteration. You can imagine where that's going to go. Scenario 2, natural persons make minimal alterations to the output of the AI system while reducing the innovation to practice. Third, natural persons perform experiments on the AI output to create a modified design. And 4, natural persons use an AI system to make minor alterations to a new design that they came up with. And 5, an owner of an AI system attempts to patent the innovation. In those 5 scenarios, you hear that there's different aspects of what the natural person is doing. And the first two, the patent office said those two do not amount to those inventors. The natural persons did not actually do the inventive part. That was the AI, and AI can't be inventors. So they pretty much like shot themselves in the foot there in terms of just using the AI to do things, and they themselves did not do it. The third and fourth examples where they modified the design, or it was really their design that they came up with and used AI to make alterations. That one did meet the threshold of yes, they're inventors. The natural persons are the inventors. And then the last one where just the owner of AI tries to patent something the AI came with, that also does not meet the criteria. So it's like if you own the AI came up with it, doesn't make you the inventor. So I think that, is really helpful guidance. And there's a lot more details in the example if you actually, do the search on this. It helps you understand how to work with AI to understand problems. And then when it comes to the materials you end up giving your patent attorney, I say a lot of, you can tell AI to draft a claim, and I get a bunch of claims. But really, I found those to be missing of what is the novel aspect. Like what are you moving the needle on? And I still feel like there's the human aspect of understanding the problem and then really articulating what the differential is, what you're addressing. That you still need that human component. Even the disclosures I get those disclosures and I push back at them. I'm like, listen, I see your general statement here, but what are we really doing different? And then that conversation is a great conversation starter. But I've actually had a client recently file a provisional on their own to try to save money. And then ultimately when they gave it to me, they're like, hey, let's make this a non-provisional. I'm like, you didn't enable what you did. A lot of wants and needs, a lot of placeholders for the disclosure that you filed, but we need to actually finish up the invention. And so I definitely feel like AI is definitely useful, but I think use it within like any other tool you have, and get some guidance on filing using AI with your patent attorney. My advice. So I think that's the biggest thing I'd say these days.
Okay, yeah, that is definitely a new thing, and yeah, I've definitely worked with AI for some legal stuff, and it's been really nice. And to my eyes, to my inexperienced eyes, I'm just like, wow, this is great. But yeah, you might see some differences. But it sounds more like you are talking about the issues with like developing the actual invention versus like writing it up, right? Is that what you're saying?
Yeah, but I mean, writing it up, I guess, is the question. What if you're just using it to expand a section for known section? Let's say you develop an IPG, you develop a novel electrode, and you just kind of want to fill out like the spec for specifications for what are the different aspects of IPG that is kind of generally known to the art aspect of what is the novel distinctions that you've identified are the limitations that ultimately would go into the claim. I still don't think AI is really, at least in my experience that I've seen so far, have been great at teasing that apart in at least in the meaningful way. But not to say it's not going to get there. I just think that there's another aspect of the law firms currently don't use AI because we're not confident that the databases that the AI pulls from the algorithm is confidential. So think that you put in right now, if you put in you think Google is free and it's a free search, etc. But everything you type into Google is not confidential. It goes out there, and there's some companies who talk about AI for patent work. They'd say, hey, we have a closed network system for you. I don't think that's true for the free products. So if you go to ChatGPT, you put your idea in there, that algorithm now has learned, oh, this idea is out there. And so next time someone else uses the idea to work on their innovation, they may pull from your disclosure that you included. So attorneys are very, very cautious because there's a lot of malpractice to not have our clients' material held confidential. So I think for individual innovators as well, you really have to be careful on where you put your ideas in. So if I use ChatGPT, or not that I don't use ChatGPT, but if I were to use a similar program to like that, I would maybe only expand on the non-confidential aspects of things that are known in the art to help fill out an application. But you always hear about companies that are supposed to hold your credit card information in confidential, and it's a data breach, et cetera, right? And I think, what is the cost of losing that confidentiality of your idea? I mean, ultimately, we want to, publish our innovation, right? We are filing a patent that will become public, but there is, the 18-month embargo that you don't have in typing in your ideas into these products. Now, I am currently exploring different options for what legal services AI offer and what kind of assurances they have. But even myself, I don't put my clients' confidential information in that, or until one day there's reassurances that we can rely on.
Yeah, that makes sense. So you're pretty confident that your job is safe for now, on the legal side of things, right?
I think innovation initially can be scary for an old dog to learn new tricks, but I think the exciting thing I see about it is it can take out some of the grunt work, but really separate out where's the value you actually provide. And that's why when I started this firm, I'm just like, what is it that I can provide? And I had a PhD. I had a bunch of depth of knowledge that I'm sure the AI has a bunch of depth of knowledge too, right? But I think the human mind for coming up with innovation is still unique. And I think my competitive advantage is still being very creative and solving problems and having the empathy of innovators, understand what the perspective they have, and help through a conversation understand what is the problem they're trying to solve. And I'm not concerned about AI taking that over. And in any case, I think there's a lot of hard problems out there that need to be solved. If AI can help solve some of them, awesome. That's what we're here to do, right? We're here to make the world a better place, etc. And if AI helps with that, that's wonderful.
Yeah, that's cool. Yeah, well, it's a brave new world we live in, and it'd be cool to have instant patents if you just input it and boom, ready to go, and then maybe you read it over, you rubber stamp it or something like this, and yeah.
Well, I'll warn you about that. AI is great in generating a ton of material, but it doesn't. You can bury the lead in it. So don't just generate material for generating material. I think it's much the claims. The reason why the claims are short. They're short, so they're broad. But I will say it's definitely helpful to provide something. But when you provide material without even reading it yourself, that's a little annoying on this side of saying, okay, did you even read what you submitted? Because there'll be prompts in there. I'm like, at least clean this up before you send it to an attorney.
That's funny. So they just send it. Wow, yeah. That's crazy.
Wow. Yeah. So
great.
I will say, but my closing thoughts is that I had some incredible mentors in my training who took time to help me gain experience, and I believe in paying it forward. I plan to hold office hours for innovators to ask me questions, and I'll announce those shortly. There's a proverb about how a society grows great when people plant trees in which shade they shall never sit. And that just reminds me of the mentors I had, and both science and law helped me become the innovation advocate I am today. So I would love to help scientists, innovators listen to this, reach out and let me know how I can help them.
Yeah, excellent. Thank you so much. Thank you, Eugene, for coming on. And hopefully if people are interested and they're in the right stage of life or development of some kind of technology or idea or something like this, they can reach out to you and learn more.
Thanks a lot, Don.
Hope you enjoyed the show and were able to learn something new, bringing together different fields in novel ways. Until next time on the Neural Implant Podcast.